Good evening. Welcome to Left, Right and Centre. I'm Vishnu Shom. On the programme tonight, just a few days back, the government defended the sedition law in the Supreme Court. Today, a dramatic U-turn led by the personal involvement of the Prime Minister. Perhaps the centre saw the writing on the wall and chose to act without risking an adverse court order which could have taken place even tomorrow. One way or the other, the law on sedition will change, but opposition leaders are not holding their breath. The government is stalling in taking a real decision, is what they say. We'll have the Trinamool Congress MP Mohua Moitra with us in just a few moments. She's also a petitioner in this case, and then we'll open it up for a broader debate. Next on the show, the CEO of Indigo, Ronojoy Datta, in an exclusive interview, defends his airline's decision to not board a special needs team, a decision which has outraged many online. Flight safety comes first, he says, but was there a flight safety issue at all, is what we ask. But first, our top debate, the sudden and unexpected decision of the government to tell the Supreme Court not to proceed with its hearings on the law on sedition. In its appeal, the government says Mr. Modi has expressed his clear and unequivocal views in favour of protection of civil liberties, respect for human rights, and giving meaning to the constitutionally cherished freedoms by people in the country. Joining us for her views on this, Mohua Moitra. Not only is she a Trinamool Congress MP in this, but also a petitioner. Mohua, the government has appealed to the Supreme Court and has said the Honourable Prime Minister believes at a time when our nation is marking Azadi Ka Amrit Mahotsav, we need to as a nation work even harder to shed colonial baggage. Is this about shedding colonial baggage, or is this a political masterstroke in a sense?
It's neither. It's just a clever ploy to buy time. It's exactly the same thing they did with the marital rape issue in the Delhi High Court. The law's been there since 1870. 150 years have passed. This government has been in power for 7 years. If they wanted to do something with the law, they had 7 years, more than 7, almost 8 years to do it in. They've done nothing. It is only now that they realize that there's actually a real possibility of this being examined by a larger bench, of a 7-judge bench. Basically revisiting 1962 Kedarnath Singh, and which is why that they are trying to do this to buy time and basically to say, stay off. They're scared of what the court will do. They say, stay off, we'll do what we want. And then they'll just sit on it for years and years and years. So it's neither a political masterstroke nor some great new embracing of liberal ideas or wanting to uphold the constitutional, validity of the law. What they want to do is to just buy time.
So, Mohua, would you therefore, as a petitioner in this case, hope that the Supreme Court continues to hear it and then establishes a time period within which the government needs to act?
Yes, what has been quite encouraging in this is that the voices that have been coming from the bench have been saying that, listen, it's high time we hear it. Whether for or against, we will hear it. And we will take a decision either way. That's been very, I think, encouraging. All of us who are petitioners and, have put in we are going to hear the reference tomorrow at 2 p.m. in the Supreme Court. So the hearing of the reference will be, we've certainly said that, look, you have to go into it a little bit. In 1962, during the Kedarnath Singh, you have to remember Article 14 and 21 was not really applied. And they heard it basically on freedom of speech, 19. So by what Mr. Sibal was saying now was, listen, let's put away 19. Let's just examine it with a 3-judge bench on 14 and 21. Mm-hmm. Let's not touch Article 19. Mm-hmm. What we are, of course, saying is that now with UAPA and with the NIA and with all these laws that are coming in, Kedarnath has already restricted. On paper, there is already a restriction. 1962, the 5-judge bench already said that you need imminent lawless action. Right. You need constitutional validity is upheld, but the restriction is that you have to subvert government action by incitement to call to violence. Mere criticism is, it's not sedition. But if you've seen in the last 7 years or the last 10 years, that's not exactly what's been happening.
No, it's not.
So
in
we
fact,
cannot
that part
use,
of the protection against misuse has been completely disregarded.
Completely. So we have to relook at Kedarnath, and a 3-judge bench cannot relook at Kedarnath, which is why Mohua, a reference to a larger bench is necessary.
Just referring to what you're saying, when the government says, and the Prime Minister's name is liberally mentioned in this, it's almost like a political appeal to the Supreme Court, which I find interesting, that, you mentioned Azadi Ka Amrit Mahotsav, you mentioned that the Prime Minister has done this, etc., etc. Be that as it may, if the government says that they are fully cognizant of various views on the subject of sedition, having considered the concerns of civil liberties and human rights, while committed to maintaining the sovereignty of India, doesn't this really beg the question, if you're so worried about human rights and civil liberties now, what stopped you from being concerned about it yesterday?
That's exactly the point. That's exactly the point. And in which case, let this be given to a larger bench, a 7-judge bench, and let the Attorney General has already stood up, who's the highest law officer of the land. He has already stood up and said he is ready to argue. So in which case, if the Attorney General is ready to argue, please stand up and please espouse your cause. Say that the Prime Minister is only too happy to get rid of this. And, let us examine it on 19, on 14, on 21, within a larger, I would say, benchmark, and have a 7-judge bench take it forward.
If
and
they
let
were
the
to
government
drop this all together, is that something you would welcome? Because that's ultimately
not
what
at
you
all.
want.
Not at all. And I sincerely hope, and I am confident that the court in its wisdom will not do that.
No.
Will not
I'm
be
saying
taken
if
in
the
by
government
this law.
if the government were to drop the definition of sedition as it stands presently, is it then that you would welcome it?
Yeah, obviously, but
that is your goal, right?
Has been in,
but you're worried that they would alter it, with new grounds.
Vishnu, you are a news anchor, a seasoned journalist operating in this environment. You tell me, do you have any faith in the government's good intentions? They've had 7 years or 8 years to do it. And they've applied sedition on everybody, from comedians to journalists. Nobody has faced it more than you guys. So do you have faith in that? I don't. I actually don't. And they will bring it back to Parliament and put some twist and turn and do something to it. And they'll say, look, we want reasonable restrictions. These are the restrictions. And they have a brute majority. They'll pass it.
All
and
right.
then again, we wait. So while this is literally on the eve of some kind of solution, I think I can just leave it to the judgment of the bench to take it forward.
All right. Well, let's see what finally happens. And perhaps it's going to be long drawn one way or the other. Moha Moitra, thank you very much for speaking to us.
Thank you so much. Thank you.
Well, we're going to have a debate on this. Joining us now, Arima Sundaram, the senior lawyer of the Supreme Court, and another senior lawyer of the Supreme Court, Sanjay Hegde, with us as well. Arima Sundaram, how would you respond to those who say that this is essentially the government stalling for time, that, it's not the last end, it's not the end of this debate. We really don't know what way, shape or form the law on sedition is going to take in the future.
Well, the way I would really see it is, I'd like to keep the two separate. One is the government seeking time from the Supreme Court and seeking an adjournment of the case. That is a matter the court will decide on its own terms, on its own merits. I have nothing to comment on that. But what I do have to comment on is that I, for one, have always felt that sedition as a law is necessary.
Right.
But in its present form, certainly not, because it's become a tool for complete misuse and misinterpretation. It's too fluid in its definition. It allows room for misinterpretation, and thereby it allows complete misuse of the law. I believe that sedition as a law was meant to be a bulwark, meant to be a defense for India, the country, not of a ruling party of the day, but India as a country, by any kind of attack which affected its sovereignty, its integrity, its security. And that is the object. The section, unfortunately, worded as it is in the loose manner it was, because in the British days, the colonial days, they wanted to use it also as a tool to protect king and government, being the British government, against any kind of colonial upheaval against the colonial rule. But that is the hangover which we have kept the definition for what it is. And I feel the definition ought to be put into a very, very, very strict straitjacket with no room for discretion, stating exactly what would amount to sedition. And like I said, an affront, an incitement to violence, public disorder, which will affect the sovereignty, unity, integrity, security of India.
That's again open to
now,
interpretation.
Coming to the affidavit filed by the government, what it really shows me is one thing, that the government, from a stance where they were saying, no, the law, let it stand the way it is, which all governments have done since the law came in. I mean, we've had governments of whichever hue doing the same thing. But what it really shows is that today the government has understood that, look, this is the mood today. This is the way the courts are also looking at it. This is the way the people are looking at it. And I would like to think, and I would like to believe, that the government is being responsive in saying, look, all right, if this is the thing of the court, the mood of the court, let us also see how we can alter this law and look at it objectively and see what we can do. So that is different. The seeking an adjournment is a different matter. I have nothing to comment on.
All right. Okay.
But so far as this is concerned, I feel it's important that the government is willing to, has shown its willingness to say, yes, if this is the mood, we will have a relook.
I get that. I get that, sir. I also must go across to Mr. Hegde, who's been waiting very patiently. Sanjay Hegde, do you see that in the same light as what Mr. Sundaram is saying? That look, one needs to appreciate what exactly it is that the court, what exactly it is that the government is now trying to do. Look at it in that light, or do you feel that this is just a step which has been taken because it was not looking good for the government in terms of the various pronouncements which have been made by the Supreme Court on the issue of sedition?
Well, I've been a lawyer long enough to tell you that no case is over till it is over. And I have also been a government lawyer long enough to tell you that when a government starts stalling for time, or when a government thinks that a particular constellation of judges may not be there very long, an adjournment is often a good idea. So let's put it bluntly. If the government wanted to get rid of the sedition law, all that it required today was for the president to sign an ordinance.
Right.
And this government has never been ordinance shy. They've even brought in the EWS quota overnight by an ordinance.
Right.
So this thing that we shall consider, take an opportune view, and then this is the Azadi Gold Amrit Mahotsav, etc., etc., etc. I will believe it when I see it.
And so therefore the question that everybody would want to ask is, if the government isn't following the ordinance route, where do you see this going? Would I be correct in saying that there could well be a Supreme Court hearing which continues, where the Supreme Court says if you are making changes, it has to be done within a time period? Or do you believe that this now moves to Parliament, where the law needs to be changed and the government will then vote in the changes, and then we debate on what constitutes sedition then back in Parliament?
I can't predict the future, but as far as the court is concerned, the court is being told, why do you want to waste time on it? We are re-looking at it. Tomorrow, the court has to first take a call on whether 3 judges are sufficient to read down the law or do away with part of it, or whether they would have to refer it to 7 judges. If they refer it to 7 judges, it obviously takes time. The court is looking at a vacation in May and June, and post-July, we never know what the situation will be. Sparing 7 judges for a hearing like this often is an administrative task for any Chief Justice.
Mr. Hegde,
going through the parliamentary route, when Parliament assembles again during the monsoon session, I don't think the first item on the agenda will be, okay, let's do away with sedition law, or the Indian Penal Code Amendment Bill of 2022 will not be the first item. So,
sir, I think what a lot of people would want to know is that when they read the news or they hear that the government is having a rethink at sedition, I think it would be safe to say that it's just a rethink. It's nothing that's going to fundamentally change for a while. Are you optimistic? Are you optimistic that we are headed in the right direction? That journalists like me and others will be free to say what we want? That dissenters will be free to, or they'll have 10 cases against them from various parts of the country, even going forward?
One can hope for the best, but then one must remember what Prime Minister Narasimha Rao used to say. I think about a problem, and it's not as if I do nothing. I decide that nothing can be done.
Right. All right. Okay. Fair enough. Arima Sundaram, we've got you back. So just a final question to you, sir. Earlier on, you were saying that the law of sedition needs to be protected in our country, but obviously there need to be defenses to ensure that it's not misused. But ultimately, sir, isn't it all a question of interpretation? And therefore, aren't we back to square one? If I say something which some people say affects the territorial integrity or the sovereignty of our nation, it's an issue of interpretation, and therefore I could be accused of sedition. How is it possible, sir, to define the language or the terms or the contents to protect sedition on the one hand and freedom of speech on the other?
Well, let me put it this way to you. Every statute whatsoever in the books is capable of interpretation. and its interpretation is always called upon to be done by the courts to be done, and the courts do it in keeping with constitutional safeguards. Now, the idea is that we have constitutional safeguards in Article 14, Article 21, Article 19, freedom of speech, freedom against arbitrariness, freedom of right to life and liberty. All this is there. Now, the point is to say that a statute is capable of misinterpretation, so let's do away with it. Then let's not have any statute. Every statute would be there, which is capable of being interpreted, and an interpretation may come up. Right. But the point I'm making is, the section as it stands is too wide. It can naturally be interpreted to take into its compass actions which are not really what I would call for are things to protect the integrity or the sovereignty or the security of India, sure, but more colonial in nature. If we were to outline very clearly that sedition shall be the following acts and none other, 1, 2, 3, 4, and then somebody tries to apply that section, right, to a given situation, right, then you're correcting the exercise of power or the misexercise of power, all right, which is the job of the courts to do, and the courts will always do that. Well, and that is the case in the case of any statute. Well, let's but you can't say, because the statute may be misused, right, we should do away with the statute.
Let's hope those statutes are now defined much more clearly perhaps than they are now, and let us hope that the right to say what we want to as a democracy is enshrined by any law that comes to replace this, or if this is removed in the form that it exists. Thank you so much for being with us. There are lots of comments, as you'd expect, on this. On coup, Parangav writes in, says the government themselves were not confident about the amendments in the law. Rohit Kapoor says the Prime Minister knows if he will not intervene, then it will go against his government. That's an important point. Was this a political masterstroke to actually take a decision to say that it champions freedom of speech before some sort of adverse judgment came this government's way? Well, next on the show, the CEO of Indigo, Ronojoy Datta, in an exclusive interview, defends his airline's decision to not board a special needs teen, a decision which has outraged many online. Flight safety comes first, he says, but was there a flight safety issue at all? Thanks, sir, very much for being with us. Now, sir, you'd be aware there's this article which is, it's come out on Facebook. It's a post where someone says that the parent of this child told your airline manager, do you know what it means to be a parent to a special child? Do you think as a mother I would ever let my child harm himself or anyone? Did your airline manager know more than this parent?
No, of course not. Not even close, I'm sure. However, flight safety is something that we take full responsibility for. We don't outsource it to other people and take their opinions and input. And really, let me first talk about the overall philosophy of flight safety, because it's very important to understand that. We say we have these pillars, which are customer service, affordable fares, reliability, and they're very important. However, we always tell our employees that flight safety is number one. And if you're in doubt, please always err on the side of flight safety. So how do we make sure that flight safety is not just lip service, but is actually working? One is training. And training, as I said, is everything else is important, customer empathy is important, but please, you are finally responsible for flight safety. The second thing is empowerment. We don't try to second guess the captain's decision when he says, I think I should divert. Or the flight attendant's decision, I think we should evacuate. Or the airport manager's decision, I don't think we should board at this time. And remember, flight safety is a partnership between the DGCA and the airline. And the DGCA is very clear on what our responsibilities are. There are two CARs, as they call, 4.3 and 4.4. And they say very clearly, hey, airline, you are responsible for screening the passengers during the boarding.
Mr. Datta, I understand that completely, and there is nothing more important than flight safety. That's paramount. But in a situation like this, was flight safety being compromised? His parents would know how to have handled his meltdown, apparently with patience, cajoling, sternness. This is what this article says. Hugs, other passengers didn't seem to have a problem. So the flight safety concern you mentioned what others are suggesting is that it wasn't a flight safety issue as well. The same passenger flew with you yesterday.
This passenger, I'm happy to say, flew with us 50 times.
Right.
Over the past few years. 50 times.
So then why was he stopped on this particular flight?
In this particular case, he was in a panic situation for whatever reason. And if you look at flight safety, incidents happen when the crew is distracted. It's never one thing. Something happens, the crew is distracted, something more important happens, and the crew doesn't pay enough attention to it. So that is why the CIRs are there. The CIR says, please scan all your passengers and make sure there's no potential disruption on the flight. It doesn't say you have to be 100% sure, but please make sure there's no potential disruption.
Right. Now, I'm not suggesting that the airline, broke the rules technically, but there is an issue of sensitivity and there is an issue of understanding. For example, apparently the airline told the parents that if the child did not quieten down and become quote unquote normal, then he would not be allowed to board. I mean, how are we using terms like normal and abnormal? What is normal to me may not be normal to you and vice versa. So,
poor choice of words, I agree. What is important is that the passenger needs to be composed. And it's not whether it's physically challenged child or a normal child or a pregnant woman. It all depends on whether the passenger is normal and composed. We tried our best. And after the incident, we took them to the hotel, came back the next day, no issues there. But we truly cannot compromise that. And remember again, the DGC is going to do its own inquiry. The rules are very clear on us. We can't be violating the rules of the CAR. Could we be more sensitive? We always try to be. Let me assure you that every one of our customer service agents goes through a training on how to handle special needs people. We do a refresher every 2 years. Every airport has what we call an eye coach that studies issues like autism, sign language, spinal injuries, and they are experts in that area, and then they try and train all our employees.
Do you believe, sir,
that
your airline manager took the right decision?
I absolutely. We went through the whole process, what happened at this time, what happened at that time. I turned to our head of airport operations, and I said, in this particular situation, what would you have done? He said, I'd do the same thing. I turned to our Delhi airport manager, and I said, in this situation, what you would have done? He said, I would have done the same thing. So we are all consistent that we are following everything that we have learned over safety, and we never want to compromise on that.
So apparently the airline manager said, or somebody in the staff of Indigo said, behavior such as this and that of drunk passengers deems them unfit to travel. Again, it's an entirely incorrect equivalence had it been made.
Well, again, I won't defend every word choice, okay? That in the heat of the moment, we can always backtrack and say we should have said this. But I think the concept is the passenger fully composed? And I think the manager is trying to say there are many situations where the passenger is not fully composed. He could have got into a fight. As I said, he could be physically ill. He could be drunk. There are many situations like that, and they all fall into the overall category of, is the customer composed?
So there was a passenger on a SpiceJet flight in 2012 who won a case in the Supreme Court, Jija Ghosh. It was about the use of prosthetics and having to remove a prosthetics before a flight through the security process, etc., etc. But while the Supreme Court did rule in her specific case with regard to the use of prosthetics, it was all about dignity of passengers who are differently abled. Do you believe, sir, more needs to be done to protect that dignity of passengers, perhaps by ensuring that your crew members are better aligned to understanding the needs of different passengers?
There's always room for improvement. Okay, as I said, we have very extensive training processes. We have very specialized people studying this on a global basis. They go for refresher training. So I believe we've made great progress. As you can see, little things on our ramp. Our ramp is designed for disabled people. If you see how a coach is designed. So the question is, are you doing enough? We're doing a lot. We can definitely do more. One of the things we should do after this internally is definitely do a case study and say, how could we have treated it differently. I'm happy to say that, this particular family has traveled with us 50 times. I hope they'll travel with us 50 times more. This was just one unfortunate incident. But I fully stand by the decision of the airport manager in the stance he took.
All right, Mr. Datta, thank you very much for coming on board. I think it's important that all airlines are transparent, and clearly that's been the effort over here to explain your position. There is a DGCA inquiry being headed, we are told, by a 3-member team which will visit Ranchi, Hyderabad to collect evidence. Let's see what finally emerges. Thank you, sir, very much for agreeing.
Thank you very much.
Thank you very much indeed, sir.